is the idea. Good afternoon, everyone. Gives me great pleasure to welcome both Professor Philippa Webb and Rosana Garciandia, both from the King's College London, for today's lecture, the lecture in this series on sustainable global economic law at the Law Faculty of the University of Amsterdam. Thanks so much, Rosana and Philippa, for joining us. The two will present their work on the persistence of practices of modern slavery in Mauritania. They are basing their presentation on a journal article that they recently published in the Journal of Modern Slavery, together with their co-author Maeve Ryan, based on quite some extensive research already, and also giving a view into what they've still been wanting to do. Yeah, so you can find snippets of both Rosana's and Philippa's very impressive biography on our website or elsewhere on the web. So it would be, without further ado, that I would thank you already once again, Rosana and Philippa, for accepting our invitation and for your presentation, and then for your readiness to engage in a discussion with us. So please, the floor is yours.
Thank you, Ingo. Thank you for the kind invitation to participate in this lecture series of the Amsterdam Centre for International Law. ACIL's mission towards the critical understanding of the role of international law in society and law's progressive development is very much aligned with our research, and we look forward to the conversation. And this being Zoom, I'm able to actually look through the list of participants and see the names, recognize some faces, and I see some very familiar and very expert members of our audience today. So Rosana and I, as Ingo has explained, are presenting an article that was recently published in the Journal of Modern Slavery. And we take a case study approach, but it is part of a broader project we have on accountability for modern slavery and using legal tools other than litigation to expose, understand, and resolve problems of modern slavery. The article identifies common negative patterns that we also call biases in Mauritanian law enforcement and explores factors that could explain those biases. So this afternoon, I'm going to look at those negative patterns, and then Rosana will present to you how the factors could be used to advance the enforcement of Mauritanian anti-slavery legislation. But just before going into the patterns, I will provide some background and context. Mauritania is a country that may not be well known to you. It is a country in Northwest Africa. It gained independence from France in 1960. It is 3/4 desert and ranked 157 on the Human Development Index. It has a small population of 4 million people, and it's composed as follows. 40% of the population are Black Moors or Haratines. It is common to define the Haratine as an ethnic group, but the ethnic mixing in Mauritania makes it more appropriate to define them as a social group that comes linked to the slave descent social status. 30% of the population are white Moors of Arab Berber descent, and the remaining 30% are Black Mauritanians or Afro-Mauritanians that are who are non-Arabic speaking. Mauritania, as we say in the abstract to this seminar, was the last state in the world to formally abolish chattel slavery in 1980. It has adopted domestic legislation reflecting international standards, such as the 2007 Anti-Slavery Act and the 2015 Anti-Slavery Act. But it faces significant challenges in its enforcement, and the government's response remains insufficient. And I'm just going to do a quick survey of some comments that have been made by international bodies and experts, including some that we've updated since the article was published. So in January of this year, just a couple of months ago, the working group of the UN Human Rights Council on the Universal Periodic Review had its third session on Mauritania. and various states made statements and recommendations. The outcome of this review will be due in the summer, but many of the recommendations that other states have been making focus on the enforcement of anti-slavery legislation and on human rights issues directly connected to slavery practices, such as gender inequality and discrimination. In August 2019, the UN Human Rights Committee adopted similar recommendations as part of its monitoring of the implementation of the ICCPR by Mauritania. And then on the sort of bilateral level, the US government decided in November 2018 to suspend Mauritania from trade preference benefits that it accorded to certain African states. And it expressly said that this suspension was due to forced labor practices and the lack of progress made towards combating forced labor, in particular, the scourge of hereditary slavery. We checked just before today, and Mauritania is still suspended from benefits under that trade scheme. So this is something that the Trump and Biden administration have agreed on. Separate sanctions relating to its human trafficking were lifted in 2020 when Mauritania was moved from Tier 3 to the Tier 2 watch list on the US Trafficking in Persons report, which is a highly publicized report that comes out each year and directly tied to sanctions. The US report said that Mauritania was upgraded. I mean, Tier 2 watch list is still not good, but it was upgraded from Tier 3 because there had been some key achievements during the reporting period, including convicting 5 slaveholders, although that was for cases pending for the last 10 years. In 2017, the African Union's Committee of Experts on the Rights and Welfare of the Child urged Mauritania to make a greater effort to eliminate slavery and protect victims and prosecute perpetrators. Slavery remains deeply ingrained in Mauritanian social structure, affecting people of slave descent, many of them Black, Moor or Haratine, and Afro-Mauritanians. Victims of slavery and their descendants suffer discrimination and inequality. They remain dependent for generations on slaveholders due to so-called cultural traditions. This brings lack of skills passing down through generations and the absence of alternative economic opportunities. The prevalence of slavery is higher among women in these social groups. Yet on the international plane, Mauritania has become what is called a pathfinder state under Alliance 8.7. Alliance 8.7 is a global partnership committed to achieving Target 8.7 of the Sustainable Development Goals. And according to its website, the pathfinder states are supposed to go further and faster to achieve Target 8.7, which is to take immediate and effective measures to eradicate forced labor, end modern slavery and human trafficking, and secure the prohibition and elimination of the worst forms of child labor, and by 2025, end child labor in all its forms. So pathfinder states must accelerate efforts, try new approaches, collaborate with others. And Mauritania is one of several states that have this status. Reports from diverse sources indicate that in reality, the existing legal framework in Mauritania is not fully enforced, and the government's efforts to effectively eliminate slavery in the country are neither effective nor sufficient. So this led Rosana and I to explore possible causes for this limited enforcement, including the history of slavery and its influence on social perceptions. We've developed this research in an interdisciplinary way with our colleague, Dr. Maeve Ryan, who lectures in history and grand strategy in the War Studies Department of King's. We've also done it in partnership with Minority Rights Group International and with the support of the King's Together Seed Grant. And as part of this, we held consultations with experts from history, slavery, African studies, literature, the Office of the Special Rapporteur on Contemporary Forms of Slavery, and other civil society organizations. So I'm now going to turn to the common negative patterns that we find when we look at law enforcement. And we have a slide that shows in one quick snapshot what we looked at in our article. So what goes behind our conclusions is a study of Mauritanian case law, reports of the UN Special Rapporteur, reports of civil society organizations who've conducted field work there for many years, the consultations with the experts I mentioned, and desktop research. And we've clustered the negative patterns into 3 groups based on who is engaging in the stage of law enforcement. So the first cluster is the government, and the pattern here is institutional inertia. This is a denial of the existence of slavery, it's insufficient action to enact an agenda to combat slavery, and it is shrinking the space for civil society to take action against slavery. So Mauritanian authorities continue to deny the existence of slavery, or at least its scale. The government standard line is to talk about vestiges of slavery that remain. In a recent interview, the president of Mauritania's Human Rights Commission, Ahmed Salem Bouhoubaini, said that he had organized in late 2019, before the pandemic, human rights caravans to travel around Mauritania to alert communities to the problem of slavery. Now, this does seem like quite a promising tactic, given the large amount of illiteracy, as I said, the desert environment, the lack of access to other forms of communication. So it was this physical moving around and educating people. But he said the result of this kind of human rights tour of the country is that there were only two reports of slavery that came out of it. And when they looked into it, they turned out not to be slavery as such, as defined under the domestic legislation, but child labor offenses. And only 2. And he said, and I quote, "We didn't find the 800,000 slaves that some people have been talking about. Some of our neighbors have a bigger slavery problem than we do because of the constitutional, legislative, regulatory, and legal arsenal Mauritania has at its disposal to fight this crime is comprehensive. What's more, we have dedicated anti-slavery courts, whereas in Mali, for instance, slavery is not even on the books as a criminal offense." Local anti-slavery activists such as Boubacar Messaoud and Biramda Abeid insist that slavery remains a major problem, contrary to such statements. So Biramda Abeid at the 2020 Geneva Summit for Human Rights and Democracy said as follows: "When you are a child and you experience injustice inherited from your ancestors, confronting it is no longer an option. Resisting is a means of survival. Your body and the spirit, even in pain, command you to raise your head." And UN treaty bodies also tell a different story to the human rights caravans, and they have called on Mauritania to gather data properly on the scope of the situation of slavery. There was a moment of hope regarding the government in August 2019, when there was a change of government, and President Garciandia came to power and nominated 6 Haratin ministers to his cabinet. I mean, there's power in leadership by example, of seeing people from these ethnic and social groups having some place in the government. He also, among them was a prime minister of Haratin heritage. And in his inaugural speech, the president made several references to combating slavery. He also met with opposition leaders and civil society. So, as I said, a moment of hope, but little seems to have changed in practice since coming to power. The official government policy towards modern slavery is social cohesion rather than ending slavery. And social cohesion, as Rosana will go on to explain in more detail, suggests an unwillingness to take targeted action to address inequalities between social groups, because you don't want to uncover the inequalities. You don't want to expose them. Instead, you want a sense of cohesion and lumping people together. The implementation of the anti-slavery national roadmap has been limited. The government has reportedly continued hampering the work of anti-slavery activists. There is a new NGO Act that may improve legal recognition and functioning of NGOs, but it's too early to tell if it's having an impact. And the government has increased funding to the special anti-slavery courts, but it remains very insufficient. And so are the resources, the personnel and the training provided to those courts. And that's also maybe something we can discuss in the Q&A. So now we come to the second cluster, where we have police and administrative authorities. And here the pattern is that of turning a blind eye, of failing to investigate and failing to protect. There are reports and patterns of the police ignoring reports of slavery. Reported cases are often not progressed to investigation. Prosecutors are not notified that a report has been made of slavery. In some cases, victims are intimidated into silence. So this contributes to a distortion in the number of slavery cases reported. The very few convictions on slavery, if they happen, are also rarely enforced. Just to take one example, and there are only very few examples, and this comes from the UN Special Rapporteur, a Mrs. Riva Mint Mohammed was sentenced to 10 years in prison for slavery practices, which is the penalty. It's sort of a mid-range penalty under the legislation, which varies from 5 to 20 years. But she never served her sentence. And the reasons for that remain unclear, despite questions from the UN Special Rapporteur, questions from the Office of the High Commissioner for Human Rights. The Special Anti-Slavery Court of Nema in Eastern Mauritania has handed down prison sentences in 3 cases, but these were handed down in absentia and the convicted perpetrators are no longer on the territory of Mauritania. So then we look to our third cluster, prosecutors. And here the theme or pattern is failure to prosecute, not surprising given the failure at the investigative level, and failure to enforce the legislation. If a report is made to the prosecutor of slavery, prosecutors often reject that claim or close the case file without reasonable grounds. They might have a single interview with the victim in the presence of the alleged slaveholder. And we've read reports where they're kept in the same room together, placing enormous pressure on the alleged victims to change their testimonies in the presence of their slaveholder, who often also holds their family. Prosecutors also reclassify slavery cases under other charges, such as work-related conflicts or exploitation of minors. Victims are encouraged to reach informal settlements. Procedures and deadlines often don't seem to be respected. As you would have read in our article, victims and the slaveholders are brought together in the same room for interrogation. We've also read reports of the victim being in the same prison cell as the slaveholder for 24 hours or more. And it's also a common practice not to make efforts to identify witnesses or to gather corroborating evidence. So what's behind this? Rosana will go into this in more detail, but we identify racial and gender biases in the way that justice is administered, increasing the risk of re-victimization through the process. Female victims in particular are quite vulnerable. If they refuse to withdraw their allegations, they may face sexual assault, or they may be prosecuted themselves for crimes such as fornication. The fourth cluster relates to the judiciary. There's a real lack of statistics here, and a constant recommendation to Mauritania is to actually gather proper statistics. But from what has been gathered by various bodies, including UN bodies, it appears no case has been adjudicated under the 2015 law. And only a few cases have been heard by the special anti-slavery courts under the 2007 law. So special courts, as I've said, have not been very effective. They have not had adequate resources or training. There's also a lack of consistent criteria for determining reparations. But at the same time, Rosana and I want to present a balanced picture. Although the picture, let's not fool ourselves, is grim, we do want to point out the moment of hope in August 2019, the fact that there are Mauritanian representatives in the government, the fact that there is this NGO law that may lead to greater vitality, and according at least to the latest US trafficking in persons report, the government has been making a greater effort to improve the special courts. So maybe the judiciary, if a case survives long enough to make it through all the hurdles to get there, could prove to be more effective in the medium term. And I now turn the floor over to Rosana.
Thank you very much, Philippa. Good afternoon, everyone. I would also like to thank Professor Venske and the Amsterdam Center for International Law for having us today. And thank you all for joining us for this discussion. So as Philippa was explaining to you, slavery is ingrained and continues to be ingrained as an accepted fact of life in some groups of contemporary Mauritanian society, as I would say, part of a long-lasting relationship between families of slaves and families of slave owners. Particularly in some rural areas, many victims do not see their situation as illegal and do not aim at escaping or accessing redress. At the same time, some slave owners justify their behavior as giving those slaves protection and support. And some judges, prosecutors, or police officers continue to be reluctant to enforce the law as they fear being ostracized within their own communities. There is, of course, this glimpse of hope that Philippa was referring to, but we need to be very much aware of the general trends behind this. So Mauritania has ratified international treaties which create obligations to take the necessary measures to eliminate slavery and to prosecute and punish slave masters. As the working group of the Universal Periodic Review has acknowledged, Mauritania has criminalized slavery in accordance with those international commitments. But obviously the patterns that Philippa was describing illustrate that some of the challenges in the enforcement of that legislation remain actual. The consequences are devastating for victims of slavery, as you can imagine, and also compromise Mauritania's compliance with its international obligations. It remains the responsibility of the state to ensure an effective enforcement of those laws. So when looking back at how and why we started looking at this research topic and developing our research on this, I'd like to emphasize that understanding the specific factors explaining these biases for Mauritania is not only the first step for the country to be closer to tackling slavery effectively and complying with those international obligations. It is also a way of pointing out at additional methods, additional ways in which international law can contribute to an advancement in the enforcement of anti-slavery legislation by encouraging Mauritania to implement changes in those factors. So as international lawyers, we saw a particularly interesting area to look at here. Our research and consultation with experts helped us identify 4 factors that you see here in the slide that could explain these patterns. This is, of course, not a numerous clauses list of factors to explain the complex social reality that we are looking at. And as I will mention now, one can certainly find connections between the 4. The first factor is discrimination as a way of maintaining elites' social privileges. One of the features of slavery in Mauritania is the discrimination and stigma that slaves and their descendants are subjected to. which affects their access to certain roles in society, the distribution of land, or the distribution of power. Mauritanian anti-slavery activism brought slavery back to the political debate, and it did it using the language of slavery to tackle structural inequalities and discrimination. It is in this context that the government's denial of the existence of slavery has been interpreted by some as a sophisticated and deliberate strategy to maintain the social privileges of elites, the white Moors. Many talk about the reluctance of people from the ruling classes to punish their own, and also about the denial of slavery as a way to maintain the status quo. So turning to international law concerning this factor, the UN Committee on the Elimination of Racial Discrimination has made recommendations to Mauritania tackling this factor, which could have an impact in the enforcement of anti-slavery legislation. In its 2018 concluding observations, the committee welcomed Mauritania's legislation criminalizing discrimination, but it showed concerns about the absence of a definition of discrimination that is fully consistent with the convention. It actually called Mauritania to ensure that the law contains a definition of racial discrimination that encompasses all the elements set out in Article 1 of the convention, and that it provides sufficient legal protections against racial discrimination. Interestingly, the committee also showed concerns that certain traditional social structures and cultural prejudices continue to stoke racial discrimination and to marginalize the Haratin community. And he was talking about particularly access to education, employment, housing, healthcare, or social services. The committee called Mauritania to take action to improve representation of the Black, African, and Haratin communities in all spheres of political, public, and social life, and also in the private sector. And this is something that has been definitely considered in light of the recent developments that Philippa was mentioning. And the committee also referred to some other aspects that could be addressed to reduce inequality and tackle discrimination. For example, it called Mauritania to ensure that the history textbooks used in school curricula reflect the contributions of population groups that have been victims of slavery. Mauritania followed up in 2019, communicating its intention to adopt measures to implement the recommendations, and in particular to undertake amendments to the law criminalizing discrimination. However, further exchanges of the committee with Mauritania unfortunately indicate that those amendments have not been implemented accordingly. The Convention on the Elimination of Racial Discrimination is not fixated on the notion of race itself. Philippa was referring to the Haratin as the social group that comes linked to the slave descent social status, which is more accurate than referring to them as an ethnic group. It is important to note in this regard that under Article 1 of the Convention, racial discrimination means any distinction, exclusion, restriction based on race, but also on color, descent, or national or ethnic origin, which has a purpose of nullifying or impairing the recognition and enjoyment or exercise of rights on equal footing. It therefore provides an appropriate legal framework for working towards higher levels of equality in Mauritania. A limitation in this regard, though, is that Mauritania has not accepted the individual and interstate communication procedures before the CERD committee. If it did, something that the CERD committee recommended in particular for individual communications in 2018, we think that would be a great opportunity for the committee to continue engaging in what it calls a constructive dialogue with the state concerning more specific cases beyond the reports that Mauritania has to follow up about. This CRD recommendation, the one about accepting individual communications, is to be followed up in January 2022. So if there is a genuine interest in advancing in the elimination of discrimination and engaging in this dialogue with the committee, Mauritania really has a great opportunity to show its commitment by accepting this mechanism by then. Also relevant concerning discrimination is Sustainable Development Goal number 10, which refers to reducing inequality within and among countries. The dialogues and data gathering initiatives that have been launched in this context, which are many, may boost change with an impact also on the enforcement of anti-slavery legislation. And here targets 10.2, 3, and 4 are particularly relevant. The second factor explaining some of the patterns is the role of women in Mauritanian society. While Mauritania has adopted domestic legislation prohibiting gender discrimination, women are still more vulnerable to slavery. And this is partly due to gender inequality and to gender biases in law enforcement authorities that Philippa was referring to. Access to land, access to justice remain two of the areas where progress is limited, with, for example, inadequate legal aid and counseling available to women, and something that's quite striking, giving less weight to the testimony of women in court. In the third cycle of the Universal Periodic Review, many states made recommendations regarding eliminating gender-based violence and discrimination, ensuring access to land, empowering women and girls through access to public life, access to work, access to education, and that is a very positive thing. Although those recommendations didn't explicitly mention access to justice and the fight against gender biases in how justice is administered. And that we think is equally important and should be part of Mauritania's strategy to implement those recommendations. And we do see how that would also have an impact in the enforcement of anti-slavery legislation. The work of the Committee on the Elimination of All Forms of Discrimination Against Women is obviously particularly relevant here. And it does seem to be resulting in some positive changes. If we look at the recommendations that the committee issued in 2014 about these issues, and we look at how Mauritania has followed up reporting progress, there seem to be some indications that training on access to justice, human rights, women's rights are now part of the curricula of the National School of the Administration, Journalism, and the Judiciary. There is also more budget being allocated to policies that look at the advancement of women and gender equality, empowerment programs for women. So this is an area where the government seems a bit more open to implementing changes that could have an impact in the enforcement of anti-slavery legislation. And therefore, we do see an opportunity here to tackle this factor with indirectly an impact on the fight against slavery and a better enforcement of anti-slavery legislation. Closely linked to the gender dimension of slavery, the third factor that you see in the slide that could explain some of the biases we are discussing today is the instrumentalization of Sharia law. It's instrumentalization as a means of maintaining slavery, again, by those who hold power in Mauritania. Why am I saying this? Because while modern Sharia law still contains elements that could be understood as legitimizing or allowing slavery in some exceptional circumstances, slavery is effectively illegal in modern Islamic countries. If we look at other countries that also use Sharia law as a legal framework, they've effectively criminalized slavery through secular law and international commitments. Yet in Mauritania, female victims of slavery often fear accusations of extramarital sex. Their testimony, as I was saying, may be less valued than that of a man, and that remains a big concern. Again, turning to international law, Mauritania has made reservations to Articles 13 and 16 of the Convention on the Elimination of Discrimination Against Women based on Sharia law, something that the CEDAW committee and the CERD committee have made observations on, but unfortunately with little success. In 2018, the CERD committee recommended Mauritania to ensure that the reference to Sharia law in the constitution does not prevent the full application of the provisions on the convention in its legal system and is not interpreted or applied in a way to impede the enjoyment of rights set forth in the convention. So as you see, there is a very important element to be addressed here. And finally, connected to this, the fourth factor we talk about in the article that you've read is the resistance to the international human rights discourse by certain legal professionals in the post-abolition period that we look at. The reason for this could be that it is seen as a Western approach, not taking into consideration the Islamic understanding of rights. And that is, we believe, quite a relevant factor to keep into account in this analysis. In its report following up on the CERD 2018 concluding observations that I referred to before, Mauritania expressed that, and I quote, "It remains committed to continuing its constructive dialogue with the CERD committee and successfully implementing the comments and recommendations made." As you know, Mauritania has recently inaugurated its membership of the UN Human Rights Council. And that may, together with those glimpses of hope that Philippa was referring to, open the door to a new era in the country's commitment with human rights. However, in order for that to be a genuine dialogue, it will have to address issues as the compatibility of Sharia law with human rights international treaties, and very importantly as well, reforms ensuring that its laws do not prevent criticism of human rights violations. In our article, we also emphasize the potential influence of foreign investors and businesses who could use their leverage to encourage a more systematic enforcement of international human rights standards and some other interesting dimensions of international relations of Mauritania with neighboring countries. So wrapping up, as we've seen today, despite Mauritania's visible role as a pathfinder state against slavery, and despite some timid improvements, there continue to be indications of challenges in the enforcement of its anti-slavery legislation. We have argued that these challenges are connected to certain negative common patterns or biases in law enforcement practice, and that these patterns may partly be explained by factors such as race and gender discrimination and the instrumentalization of Sharia law and of the legal system to maintain the privileges of certain elites. The deep interconnections between slavery and other fundamental social issues that we've touched upon, such as discrimination of certain groups or the role of women in society, need to be considered when identifying what else could be done from the international law perspective to better protect victims of slavery and to eliminate it. As we saw today, there is great potential in the role that CEDAW or the CERD committees could play in this regard, particularly so if Mauritania, now a member of the Human Rights Council, accepted the CERD individual communications procedure. This would add to the efforts of regional human rights institutions engaging with Mauritania on these issues. Thank you very much for your attention, and we look forward to the discussion with you now.